fairly often. We're 1 month in right now. So a month ago on the 15th at night, 6 o'clock at night, we were all told to, or not told to shut our offices down, but highly recommend only seeing emergencies. So 1 month in and at least a month to go, right? I think probably everybody's missing social contacts at this point. Everybody's going a little bit stir crazy. I know David was talking about his dog before, hopefully not jumping in on the webinar, but a lot more people out walking their dogs now. Everyone's giving each other 6 feet of space. It's kind of entertaining. I'd like to thank a couple of people as well. Michaela Fitzgerald and Claire at the ODS have been doing a phenomenal job. It's amazing actually how much time I think Michaela's put in behind the scenes that people probably don't realize. Claire as well, even just getting the mask fittings organized, the PPEs, and just trying to disseminate the information to the people in the ODS. So shout out to all the ODS executives, but Michaela in particular. Sean, for getting this organized, by the way. Sean, who's not a lawyer, but I'm trying to get him to be a lawyer. Kind of looks at right now. You know, I've been very fortunate to be able to work with Gordy Schwartz, who everybody knows. And, you know, Gordy often comes up with some very good sayings. And he said to me once years ago that you want to surround yourself with people who do their jobs as well as you do your job. And in my situation, it's not that hard because I don't know how well I do it. But I feel very fortunate actually over the years to have surrounded myself with some great people. And I think it really, you know, it helps you evolve and develop, and when you can tap into information, that's been great. So, you know, David's a fairly new contact to me, but Harold I've known for not quite 30 years, but not too far from it either. One of my first intros to Harold was through Danny Seller's brother, Freddie, when they didn't want me on their team anymore. I don't know, it was like too many penalty minutes or something like that, and I was Harold's last draft pick in the league 25 years ago. So, you know, where like Harold's obviously a very, very bright guy. He could actually, I think he's the only guy I've ever seen talk a referee out of a penalty. I don't think I've ever seen that before. So, and Sean Corcoran actually was a ref, known in hockey role as well, right, from West End Hockey League for years. So, and David is we'll do the CVs afterwards, but David's obviously quite an athlete as well, including being in the Olympics and cycling. So I'd like to see you and Mike Rapp on a couple bikes together, see who wins. So I feel very lucky to have Harold Feder, who's a partner with Brazos Seller Law and was called to the bar in 1990. So like us, 30 years in, eh, Harold?
Long time.
Long time.
Seems like just yesterday.
Your hair looked as good as mine when you first started, didn't it?
Pretty much. I may have had one or two more strands.
Yeah. So you're more into the business side of law, right? With being a
Correct.
multifaceted background, extensive tax experience, and a broad legal practice. Harold has an acute ability to recognize the underlying tax issues in business transactions, which I can attest to firsthand. Harold specializes in tax and estate planning and corporate commercial law, with a particular emphasis on providing tax-effective structures for wealth maximization and providing legal solutions to healthcare and other professionals. Legal services for professionals and practices including incorporating, practice sales, leasing, and the preparation of partnership association, shareholders, and associate agreements. The rest is a little bit redundant, so I'm not going to read that. And then we've got our friend David Spears here, who might be as relevant or more relevant right now. David, you're more into the employment side of things, eh?
That's right, yeah. Employment related.
Yeah. We've had quite a few conversations in the last little while as well. David provides advice and representation to clients with respect to workplace issues of all kinds, including employment litigation, which we're hoping not to get into, employment standards, complaints, human rights proceedings, and occupational health and safety matters. That kind of jumps out right now, doesn't it? He also assists employers in developing and implementing a variety of workplace contracts and policies. I imagine most people have employment contracts in place right now, but certainly this would be an example where you certainly need one. Has appeared before, so David has appeared before numerous arbitration boards, federal and provincial labor boards, human rights tribunals, and other administrative tribunals. And you're often in front of the courts with respect to employment litigation. You guys frozen there?
I'm okay.
Oh, I can see it. Hear you now. Yeah.
Yeah, okay, perfect. So we had a bunch of questions that were sent in. And I think we're going to be able to get some live questions as well. Sean, which you'll be able to jump in with?
Yep.
So, David, would you mind just jumping in and sort of explain what CEWS and CERB actually stand for and where we're at with them right now?
Sorry about that, Cameron. You froze.
I was asking.
If you could repeat that, I'd appreciate it.
I was asking, Harold, can you hear me pretty well?
I can hear you perfectly. Yeah, I'm okay.
I was asking what the CEWS, Canadian Emergency Wage Subsidy, means and sort of where.
Are you guys able to hear?
Harold, do you want to jump in and maybe answer that one?
Sure. So CEWS, Canadian Emergency Wage Subsidy, and the other one is the CERB. Essentially, the important distinction is one, the wage subsidy, the CEWS is a program, a relief program for employers, and the CERB is a relief program for employees. So the CERB is a $2,000 a month relief program for employees. The CEWS, in broad strokes, is a 75% wage subsidy to employers with the intent that they would pass it on to their employees. And I think another important note about the CEWS is that the government is asking that employers make best efforts to top up to 100%. So there's a real debate, I think, out there about situations such as dental practitioners who have zero revenue about whether they want to bring all their employees on and what would be required of them in terms of a top up, which would leave them short 25% on their payroll. So, that is an important thing that people are watching. The best efforts requirement has not been fleshed out quite yet. So it is something that the government has mandated, but we don't have all the details yet.
Yeah, I mean, I think it's so fluid, right? And it's been changing every day. I have to say it's impossible to follow all the sources of information, but the government's been doing a fairly good job on keeping us informed. So I don't know if you're back on, David, or not, if you can hear us at this point.
I can, and I apologize. It keeps freezing on me. If it continues, I'm going to go to maybe non-video and see if that helps. But I'm back for now.
One of the questions that was asked was, I heard that employees should be given a written notice of their layoffs, something beyond ROE. What should legally be included in that written notice, and why is it necessary?
And that's a good question, Cameron. As you're aware, a whole lot of dentists and other employers out there have relied on or gone to temporary layoffs to address this unprecedented situation we find ourselves in. And there are no specific legal requirements for a layoff letter, although it's highly recommended. And what we recommend to clients in the layoff letter is number one, to simply state the reason why you have had to make the decision to issue a temporary layoff. I think it's important in the circumstances that you share with your employees that that COVID and government reaction to COVID and the college's recommendations have been such that you have really no choice but to shut down your practice for a temporary period. So I think it's important to set the stage as to why the layoff is happening. And then just simply clarity as to when the layoff would be effective, the date that the layoff is effective, and the date that you expect a recall to employment if you know that date. And I think for a lot of people, there's a tremendous amount of uncertainty about when.
Just lost him.
Simply to leave blank. We recommend that in the letter you make it clear that that it is a temporary layoff. In other words, the employment relationship continues to exist, and the temporary layoff is simply a temporary suspension of their employment for a period of time, and the expectation that the employment will continue once they are recalled to work. The final thing we recommend is that if you provide benefits to an employee as part of their compensation package, you indicate, if you're able to afford it, that those benefits will continue, again, provided you're able to continue making those contributions. And if an employee needs to contribute as well to that program, that they have a way to do that. So it's not a legal requirement per se, but highly recommended.
So why is it advantageous to continue the health benefits? Does it impact how quickly you can bring them back, or does it affect the timing on how long you can keep them laid off for? Because I don't know that everyone's confident. You know, we turn the businesses off like a light switch. You know, I don't think it's going to come back on like a light switch. I think it's a bit of a dimmer switch. And I imagine that the rehiring of people is going to be a lot more staggered than when we laid everybody off, obviously. Is there advantages to continuing the health benefits as far as length of time you can bring people back with at this stage, or?
You froze for a little bit of that, but I think you raise a good point. Number one, there's a tremendous amount of uncertainty as to when you guys will be in a position to partly start up or completely resume the practice you had before. And bringing your employees back on a staggered basis is something we have discussed, and really it's a sensible way to gradually as to capacity, and you would do that by selecting those employees who are best able to fulfill the duties that you need at the given time. As far as continuation of the benefits, we recommend it really for a couple of reasons. One is it allows you to extend the length of a temporary layoff. A temporary layoff under the Employment Standards Act is a layoff of 13 weeks or less, but it can extend up to 35 weeks in a 52-week period if you continue an employee's benefit plan. So it's an important way to extend the length of a temporary layoff. The question becomes when will life come back to normal for everybody, for dentists in particular, and we don't know if that's going to be within 13 weeks or further down the road. So the ability and flexibility to extend your temporary layoff is important, and a continuation of the benefits helps with that. The other
I'm trying to
in place is there remains an argument, and it is simply an argument that a temporary layoff is a constructive dismissal. In other words, a repudiation of the employment agreement. I think in the circumstances, a court would likely say it isn't. But one of the things you want to protect against is on layoff and not having a plan in place. You run the risk. It's a second important reason.
I lost you there for a little bit. I don't know if there's a way we can work on this connection, Sean, or is it just the world we're living in right now?
I think it might just be his connection. I don't know if there's a way, maybe if it's a laptop, maybe he can move a bit closer. But
we had a couple of follow-up questions, and maybe Harold, you can jump in to see if it's any better. With regards to the letter sent to patients, can employees start legal action against the office because they have not been given notice or severance?
Sure. So I'll step into the employment sphere, and David hopefully can jump in. Maybe try getting rid of the video and
sorry.
So
Guys, I froze out again. I don't know how much you caught my
David, do you want to try disconnecting and reconnecting, David, and maybe don't bring up your video? John, can you boot David off and then have
he's off. Okay, so let me give that a shot, because it was what David was talking about. But so technically, and there are articles out there on this subject, technically a temporary layoff, unless it's specifically provided for an employment contract, is in fact a constructive dismissal, and it very, very rarely is provided in an employment contract, except in the case of seasonal businesses, which none of us have. So while technically it is a constructive dismissal, I think all of the employment law practitioners out there are suggesting that in this environment, a court is very, very unlikely to make that finding and give an employee the benefits of severance. I think this is a whole new world, and in this context, temporary layoff is a perfectly reasonable approach by an employer.
One of the things when I reached out to David a few weeks ago is the term that he used was, did you do a reasonable response in unusual and unprecedented circumstances? And I think that's what we're faced with right now. So it's best efforts at this point. With regards to the
David.
Layoff letter, would it be necessary?
I apologize.
Okay, David. With respect to the layoff letter, would it be necessary to state that all pre-layoff terms of their contract will remain unchanged?
Thanks, and again, I apologize to everybody. It's a good idea. That's really what we mean when we say the employment relationship continues. It continues on the same terms and conditions once an employee is recalled to employment. At least that's the general intent of a temporary layoff. It's a momentary suspension or a suspension of their employment for a period of time. And when they are recalled to employment, they would continue under, as you say, the same terms and conditions that they enjoyed before.
So Cameron, maybe I could pose another question to David, because I think this is what's on everybody's mind, is the possibility, like Cameron said, that the return is not a light switch, but a dimmer switch. And the fact that you might need employees back, but maybe unable to afford full pay, and what the impact of that would be if you hired employees back at 75 or 80% pay or some lesser number, and how that would be viewed.
Or even changing hours, right? We may be in a different world where we're all working Sundays to try and make up some time or lost time in the clinic. Or are you allowed to change their hours and their wages, basically?
Looks like he's frozen again. David, maybe try without.
I think I caught most of your question, Harold.
Try cutting your video first.
Can you guys hear me okay?
We can hear you now.
Yeah.
Okay. Can you hear me okay now?
Yes.
Perfect.
Yeah.
Okay. I think your question was, if you bring an employee back from layoff to what is the effect of that? The effect of that really is no different than the layoff initially, in the sense that it is a change to terms and conditions. and arguably brings up this argument that there's a constructive dismissal. But again, like a temporary layoff, it is a reasonable measure. So, you know, while an employee is on layoff, if you need them to come back for part-time, that's certainly open to an employer to do that. And there's opportunities for the employee to continue with employment insurance benefits while receiving partial payment from the employer as well. Part of the income that they receive may have to be returned to Service Canada to offset some of the EI benefits, but it's certainly appropriate and reasonable in the circumstances if necessary for the business.
Okay. Harold, I think this is probably most suited for you. Is CEWS, the wage subsidy, good for dentists to pay themselves if they have no income, or is the CERB better?
So it's that's a very good question, one that we've seen. In fact, I think owner operators everywhere are looking at that issue. So a few points. One, it's a numerical calculation and an eligibility consideration, which has to be looked at for each individual. I think the accountants are playing a lead role in terms of assisting owner managers, professionals with that decision. The CEWS has special rules for non-arm's length employees, which is what each of us would be with respect to our own businesses, that have additional limits on what you can recover. In theory, the CEWS is a higher benefit because the monthly is somewhere in the neighborhood of $3,400, whereas the CERB is $2,000. But as I said, because you're a non-arm's length employee, you may have limits based on what you were actually paid before that would lower your benefit, and in those circumstances, the CERB may be more beneficial.
Okay. David, a few people have mentioned that they weren't able to hear your answer regarding whether there'll be any possible litigation by the employees when we change or reduce hours. Can you please repeat your answer?
Sure. As I indicated before, a temporary layoff in certain circumstances could be viewed as a repudiation of the employment agreement, in the sense that there's a unilateral change to terms and conditions. In the context of COVID and the business situation you guys are faced with, I think it's a reasonable approach to take to address the business concern, and I think courts are going to eventually agree with that. But there is a risk, and that risk is continues with a partial return to work. In other words, if you return someone to work at half-time hours, it's in a sense a unilateral change. It raises the same concern, the same risk of litigation, but it also raises the same defense. It's a reasonable action on a part of an employer faced with unreasonable, unforeseeable, and unprecedented circumstances. So I think it's wise and sensible to use that kind of a tool to bring your people back on a graduated basis.
I think one of the terms you used with me a few weeks back, David, was it's a spectacularly unique event that we're experiencing, right? So it's, you know, I think hard to give definitive answers on something that we just haven't experienced before.
I think that's right.
Okay. I have a few stuff. Okay, here's actually, I found an interesting one. I have a few staff off on mat leave with different return dates this year. Can you please comment on their return to work under the current COVID situation from a legal point of view? I think that's a bit of a landmine.
Yeah, there's a couple of issues there. Number one, assuming you're operating and you're able to return the employee to work, you know, I think a question you would have is whether there is a heightened risk to that employee or their child if they return to work in the current landscape. So I think if you're bringing somebody back, I think you want to have clarity that there isn't a heightened risk, or if there is, that they're aware of it and they accept it. The second question there is, if somebody's on a leave of some kind, be it a parental leave or a mat leave, and wants to return to work, but the business isn't open, really what you're doing in that circumstances is changing the reason why they're away. You would effectively reissue the record of employment to indicate that they're no longer employed or no longer in receipt of earnings because of a shortage of work, rather than what they would have been before, being the parental leave. So you would reissue the record of employment. They would continue to remain off and may be entitled to continued payments through various government programs, depending what they're eligible and entitled to.
Okay, excellent. So here's another landmine question, probably more for Harold. What if a patient gets infected with COVID-19 after a dental appointment and blames the dentist? I guess the same thing could be said about a staff member.
Yeah, it's again, unique times. I think, Cameron, you and I chatted about this the other day. You have an issue of causation. In order to seek damages, you need to show that your condition was a direct result of what somebody did or didn't do. We're advising all of our dental clients to include COVID-19 as part of the consent to treatment. You're only treating people in an emergency situation, so your standard consent forms, I think, should reference COVID-19. And I think at the end of the day, it comes down to having taken reasonable precautions to ensure that your facility is COVID-19 free. And even if they were able to show that it happened in your location, I think the standard of care would be what is reasonable in the circumstances. And it's impossible to rule out all possible triggers and contagions, but as long as the precautions were there, and I think you should be okay, even if the person could get past the causation issue, which would be very, very challenging, I think, given the current circumstances and the degree of contagiousness of the disease.
Yeah, agreed. And really, we don't know what it's going to look like when we return, right? Anybody at this point is simply guessing. Actually, Harold, I'm going to get you to jump in on this one as well.
Sure.
A lot of people at this stage are trying to either defer or not pay their rent, and even operating, maybe blended. How do you communicate with your landlord? Is an email good enough? Do you have to have a verbal, written letter, registered letter? What are you recommending to your clients who are having a difficult time paying rent?
Yeah, we're getting many of these questions. I think one universal tip that I would pass along is that your initial approach to the landlord should be just that, an approach. It shouldn't be a demand. It shouldn't be a unilateral withholding of rent. It should be an approach. It should be an invitation for dialogue. Landlords read the papers. They watch the news. They're on Twitter. They're on LinkedIn. They're seeing everything. They get it. And so I think for the most part, landlords are open to the dialogue. And what is turning them off, I've heard this both from my tenant clients and my landlord clients, are the demands, or are the unilateral, I'm not paying you rent or for this time. So the first thing, and I can't stress this enough, is the approach should be open, candid, an invitation for discussion. Most landlords are being sensible, and they're agreeing to, at the very least, rent deferrals, if not rent abatements. So the deferrals are there. Typically what it looks like is for a certain number of months, you don't need to pay rent, and it'll be paid back over, fill in the blank, the remainder of the term, a year, 2 years, something that's reasonable, often without interest. Once you do reach an agreement, it is important because there are special rules about agreements relating to land, and a lease is an agreement relating to land, that you evidence the agreement in writing and with a signature. So an exchange of emails is not enough. There should be an agreement. It doesn't have to be very formal, but it should be signed by both parties. A couple things to think about that should be in there besides the actual rent relief: confidentiality. Landlords may be making different deals with different tenants in the circumstances. So you want to ensure that for both parties, there's an obligation to keep the agreement confidential. You may want to consider, if you're going to have 6 months of rent reduction and or a relief or deferral, that you tack on 6 months of term if you want at the end, because you're not running your business at this time, and maybe you want to add on, maybe advantageous to ask to add on additional term. And I think another very important point is that you include in your agreement that the non-payment of rent is not considered a default, because there are many provisions in a lease that are only applicable and only of benefit to the tenant if there hasn't been a prior default. So even though the landlord is agreeing to the rent deferral, you wouldn't want, if you were looking for a renewal, for example, and it says it's only available if there's not been a default in rent in the lease, you don't want the landlord to be able to say, I don't need to grant you that renewal because you didn't pay rent. So I think having a clause that says specifically that the tenant is not in default during this period is very important.
Have been people been distinguishing at all between the base rent and operating costs, or is it there people are?
Yeah, for the most part, landlords are only talking about the base rent, and the operating costs are something separate, and they're expected to be paid generally.
David, I think we just received a question here. This was probably more geared towards you. What happens if you rehire an employee and then you realize that that maybe there was a surge of work, and then you get through that backlog, and all of a sudden there's a little bit of a lull again? And are you able to lay them off again? Would they be able to collect EI again?
The answer is yes. You can lay them off again, provided you're within that 35-week period within the 52 weeks. So if you've brought them back and the initial layoff period was 20 weeks, you would have another 15 weeks of layoff, and it would still constitute a temporary layoff. So the layoff and return and layoff is consistent with the Employment Standards Act and consistent with employment insurance benefits, provided they've otherwise qualified for them.
Okay. We're having quite a few staff wondering about getting CEWS, especially the higher paid employees like our hygienists, who are typically in that $40 to $50 range, let's say. Having no revenue, a lot of the dentists feel that they can't absorb the 25% copay. And this is probably putting you on the spot, but do you think that we will actually be required to pay that 25% now or in the future? And what would be a diplomatic approach to the employee about telling them that at the present time?
So I'll take a stab initially. I commented on it a bit earlier as well, indirectly. So the government has said we want a best efforts top up by employers. So the intention, I think, of this wage subsidy is to put people back to work or get them 100% onto payroll. It seems to me that if you can't make the difference, that you're best off being honest about it. And if we get employees coming back onto payroll at the 75% rate, and we get more guidance from the government, I think it's going to be, you use the word fluid. Daily we're getting new updates, new commentary. So I think for now we have this best efforts requirement. How that gets put into practice remains to be seen. But I think from an employee standpoint, they'd rather be receiving 75% of their wages than just the limit on the CERB. So if you can bring them back onto payroll for now, but I think you got to be monitoring what the government is providing in terms of the best efforts, and knowing that you may be on the hook for the 25% at some point. It's not entirely clear. Let me just add too about, because there were a few questions about the interplay between the CERB and the CEWS. The CERB is intended to be for employees who are not working, and the CEWS is intended to be for employees who are being paid. So there is an overlap, and the idea is if there's a period that overlaps, the portion of the CERB received by the employee would be ultimately refunded to the government, because you can't double dip.
Okay. This is actually an interesting question. If I own a practice, can I pay myself the $874 per week under the CEWS?
So again, it's a mathematical calculation. I don't want to get into the details. That is the upper limit, but it's also limited by what you paid yourself prior to the hidden enemy, prior to the shutdown. So it's not automatically paying $874 a week. You're limited by what you paid before. So you can't just start yourself on a salary and collect the $874 per week if you weren't paying yourself before in that same manner. There was also a question about dividends. So dividends are received in your capacity as a shareholder of a corporation, whereas salary is in your capacity as an employee. So I don't think there's any limit. I haven't seen anything limiting the ability to take dividends and collect the CEWS. But conversely, if you were collecting dividends before and not salary, then you can't use that in your calculation of the CEWS. You're receiving that remuneration in a different capacity, and you can't apply one to the other.
Okay. My understanding is that you pay your employees 100% and later collect the 75%. It's what I've been doing with my manager. I don't understand how you can wait and see if you can top up or not. Please clarify.
So yeah, the idea is you're paying your employee and you collect it back, but it's unclear whether you have to get to the 100%. So you could, in theory, pay the 75% and wait and see on how it's mandated. What does best efforts mean to top up? And in a situation where there's a complete shutdown and no revenue, and they're not actually working, that definition of best efforts may be different than if your revenue has been dropped, 30%, which is the threshold requirement. So, what does best efforts mean in different circumstances remains to be seen. But I think where you're dealing with a 100% loss of revenue, best efforts would be a lower threshold than if you were dealing with a 20 or 30% loss of revenue.
Okay, I have to read this question because I think it's the favorite one I've gotten so far, but it's unfortunately from an anonymous attendee. What are my obligations to rehire staff? If Susie was a problem before COVID, am I obligated to rehire her? And I always use Sally, not Susie, but
names have been changed to protect the innocent.
Yes, exactly. Do you have to hire back all of your employees? I imagine those will be the ones that you'll be bringing on, later than they'll be the last to be brought back on. But is there an obligation, David?
There's no obligation. Obviously, if you don't recall an employee from a temporary layoff, then you're effectively terminating their employment. So you're going to have an obligation to that employee for notice and severance in accordance with either the employment agreement they have or common law. So you can't get past your obligations on termination because of a temporary layoff or because of the COVID crisis.
We touched on this before, David. You cannot give somebody notice right now during this layoff. Is that, did you just say that?
Well, you certainly can't give notice while they are on layoff and have the period of layoff counting for purposes of their notice period. The common law notice or notice under the Employment Standards Act is notice while they're in being employed. So you can't, although it's a sort of a neat trick if you could pull it off, you can't take advantage of a layoff to eliminate or reduce your obligations to the employee.
But if you were paying in lieu of notice, you could still do it while they're on layoff. You would just have to use the full notice period, would you not?
Yeah, you would then be converting it from a layoff to a termination, which
Right.
would trigger your obligations under the Employment Standards Act or the employment agreement, depending what is governing the situation.
Okay.
I mean, I think it's so fluid too, right? I don't know how you wonder how many, I don't want to be negative, but how many businesses will survive this as well, right? I think, dentistry, we're in a good position, but, the restaurant industry or something, like how they're going to have to bring people back. Or are you just closing doors? I think it's, I can't imagine the lawsuits. There was a lawyer in Toronto, Harold, that you and I spoke about, who was advertising about, that we're making a legal move by laying people off right now. And I don't think it really gained much traction, but can you comment on that at all?
Sure. I mean, David actually knows the lawyer personally. So I think that this lawyer just stated the strict technical legal argument that a temporary layoff, if it's not provided for in the contract, is in fact a constructive dismissal. I don't think there's any disputing that, but I think the error of the analysis is to quote a precedent from a ordinary time where the employer in the leading case had an economic downturn in its own business and use that as justification for a temporary layoff, and the court said that's a constructive dismissal. Right. But the very meaning of the term precedent means that it has to apply where the circumstances are similar. And when everybody's calling this unprecedented times, you have a very difficult time using precedent.
Hard to argue with that. So I don't, this is almost, Sean, this last question here. I don't know if there's a way we can actually do a poll or not, or if we're putting ourselves in a funny position by asking, but I was wondering if most dentists are planning to go with the CEWS, even if the employees are sitting at home and not working. Like, how many people are actually doing the 75%?
So I can actually do a poll, and I'll put it up there. Give me 1 second.
While you're doing that, the other thing I thought of, there's gonna be a bunch of questions that we may not get to. It'd be useful if we can record them and maybe put out answers in writing. Sean, if you can capture them before.
Yeah, for sure.
Yeah, we could maybe post some written comments if people didn't get their questions answered.
Also, I'm hoping you guys have a website, say, that people can jump on. Maybe must have frequently asked questions on the Brazo Seller website, I'm hoping.
We do, although we've been distributing information on COVID-19 as opposed to necessarily getting it up on our website. It's too fluid.
Here, actually, I like this question here. Do the employees have an obligation to return to work when called back by the office? If they decide not to return, must they give notice to the office? Probably a David question.
Yeah.
That is a good question. If an employee elects not to return from a temporary layoff, the employee is effectively resigning their employment. They have an obligation to give notice of resignation. Again, in these unique times, would a court insist upon some sort of obligation to give notice and require an employee to come back? Likely not. But a refusal to return from a layoff would be considered a resignation.
They may want some. Oh, that looks good, Sean.
I think everyone can see that.
They
There we go.
they want some assurances that the office meets certain standards as well, right? So which we don't know what are going to be in place when we go to return. So this is kind of going to come up a few times here. Should we rehire our employees under the CEWS, pay only 75%, or for now leave them on the CERB? I'm confused. And I think, part of that is if you have the cash flow as well, right? To hire people back and hope that you're getting reimbursed, given the size of our payroll.
Absolutely.
I can't afford to hire everybody back.
Yeah, I think that the answer is until we have more details about that 25% gap, it's a risk. And I know that there's been commentary about doing this. My view is that the intent was not just to bring people back at the wage subsidy amount and not have them work. I think the intent is to allow employers to keep them on their full payroll, and we're going to give you 75% back. So I think until we get a little bit more detail on this, the top-up requirement, it's a risk. Some may be willing to take it for some or all of their employees, but I think it's something to watch out for. And I can't sit here and tell you that it's not without risk that you're going to be on the hook for the full 100%.
And are you allowed to apply different standards to different employees? Can you top, one employee up with the CWS and leave others on the CERB, or do you have to apply sort of the standards across the board?
David, do you want to try that just from an employment standpoint, treating employees differently?
From an employment perspective, there's no obligation to recall all your employees at the same time. A lot of businesses, as you had mentioned, Cameron, will be starting back slowly, the dimmer switch approach. And so you're going to want to be able to call back those that you need first, and then gradually bring the others online as business picks up. There's no obligation that they all come back at once or that they all share the same number of hours of work, et cetera, et cetera. One thing you want to be careful about, and this is, I think, stating the obvious, but your decision to bring one employee back over another, ought to be on the basis, on a good faith basis, in the sense of what they can bring to the practice, as opposed to unlawful considerations. For example, if you were concerned about Susie because she might be pregnant, you don't want to bring her back, or something like that, you can run a risk of violating the Human Rights Code by discriminating on an unlawful basis. Some caveat there, but otherwise, I think you call them back as you need them.
I would just add, it's not really a legal point. I think it's just a office morale point, that if your office is out there anything like ours, information tends to be shared amongst employees. So if you're treating people differently, rest assured that most likely everyone will know. Everyone will know if some of them have been topped up. Everyone will know if some have been rehired at full pay versus lower pay. So you have to consider, I think, the impact on the office environment and whether it's worth that risk.
Hang on, let's just jump the queue here. Actually, a very good question again. One day I'd like to say this is a terrible question, but these are great questions. If a staff member refuses to return because they perceive that our PPE is insufficient, even if it meets the standards, can this be considered job abandonment?
Well, that's a great question, Cameron. Obviously, I think the wise practice is going to be complying with the college's recommendations with respect to safe practices, including PPE. If an employer doesn't have access to that, then they're going to have to make a difficult decision as to whether they continue to practice without the proper equipment. And I think when you do that, you take on a bit of legal risk, a bit that staff will be infected, that patients might be infected, for example. And if you've gone beyond or haven't complied with the recommendations, then you may be in a bit of trouble. So if you are unable to provide the proper equipment, it might be wise not to recommence practice. And an employee might understandably say, look, I'm not willing to put myself in that situation. And an employee has a right under the Occupational Health and Safety Act to refuse to perform unsafe work. So you would get into a fairly complicated situation there from a legal perspective.
I mean, I think we're so far away from knowing what dentistry is going to look like when we return. I think even the people who are implementing the rules right now, the RCDS, I was on their site before, and there's really no updates at all on what we can expect when we return. I think it's impossible to say what the PPE will look like, or what our rooms will look like, or HVAC system will look like. I think it's or how much lead time we're going to have to implement these things. If all of a sudden we have to have, and we're lucky that we have it here, but positive pressure in the rooms and individual operatories, I don't think we're not going to have 5,000 contractors be able to implement this overnight with dental offices as well. So there's going to have to be some time to meet the standards, and I just don't think anyone really knows what the standards are going to be.
Just to add to that, Cameron, any construction work that's required, the backlog in the construction industry and municipal permits is going to be unreal. So nothing is going to happen particularly quickly in that regard. And I'm dealing with a situation actually with a dentist where the fit up of a new space was put on hold, and everything has been deferred. So the fixturing period is going to be the same length of time that it would. It's just being pushed out by a year. But then you're faced with a situation that a 5-month fixturing period, which would have been perfectly reasonable in January 2020, is not going to be reasonable in March 2021.
And right now, there's no building inspections being done. Like we're doing a bit of a reno, and right now, or Spencer's doing a reno for us, and you can't get an inspector in for anything, right?
No.
Okay, so David, this is probably for you. If an employee is concerned about PPE and not being adequate, I'd be worried that may have a complaint. Even if you do meet the standards, but would the employee have a valid complaint against you from an HR standpoint?
If your PPE complies with the requirements and recommendations of the college, it would be difficult for the employee to say that it would be unsafe for them to return. There's an element of reasonability in that refusal, and it's not open for an employee to simply say, I refuse that because there is a risk. There's a risk in stepping out of your house. So I think it's going to depend a whole lot on the basis for the refusal. And that's something each employer can look and analyze. If an employee is saying, I feel unsafe, find out why, see if it's something you can address. If it's something unreasonable, then I think it's an unreasonable work refusal. There can be consequences for that. And it may end up the employee simply required to remain at home without pay until such time as they're frankly able to come back.
Okay. So Sean, just looking at this survey, it adds up to more than 100%.
I didn't notice that.
Yeah, I did. I wasn't a great speller, but I was okay in math. we're adding up to 105% or 104%. But it looks like most people are leaving staff on the CERB at 65%, leaving people on CRB. There was a couple people who weren't sure because they were doing different things for different staff, but let's say the majority are leaving people on CERB.
Which isn't a bad approach, and hopefully before the CRB would run out, we'd have a better sense of that very precious 25% of payroll and some guidance on what's going to be required in that regard.
I don't know who this one would be for. It almost would be a Howard Jagendorf question, guys, but our dentists, or RCDS question, are dentists liable to legal action from patients whose condition had worsened during the quarantine, while it could have been prevented had the dentist been able to see them and stabilize their condition through a non-elective procedure?
Yeah, it's a tough one.
Yeah,
I mean, there's all kinds of variables there, right? Did the patient present as an emergency, and then the practitioners say, no, I don't consider that an emergency? And, you know, what are the ramifications of the wait? I mean, it seems to me, again, I'm obviously not a dentist, so I mean, I leave it to people that understand this, but it seems to me that conditions will typically worsen gradually. So I think it all depends on the communication. If a practitioner, you know, refused to treat a patient where it could have been qualified as an emergency for a period of time, and that condition worsened to the point where you can argue negligence on behalf of the practitioner, I suppose in theory, that could be something that could result in a legal action and some liability. But I think it all comes down to the judgment about whether it was an emergency or purely elective, and whether the ramifications of the wait could have been foreseen.
Yeah, I mean, I think, you know, right now the RCDS has pretty specific guidelines on what you're allowed to treat. You can't, you know, abandon patients. You have to be screening the calls. You can't just put ODS emergency numbers on there. You're supposed to have the contact with the patient yourself. You know, the RCDS also has a list of clinics that are providing emergency care. So, you know, I think if you know, it's hard to remember every patient and what needed to be done, but, you know, if it's an elective procedure, putting a sedative dressing, et cetera, you know, maybe consider sending them off to some of the clinics that are set up with the proper PPE may make sense.
Mm-hmm.
But I think you know, I don't know how the RCDS will respond to complaints of negligence during this time. I think it's you know, can of worms they probably won't want to really attack, but you know, so I think you know, maybe sending them to a clinic that's seeing emerges, that's on the RCDS website, maybe something to consider if they think it's something that's relatively urgent.
I think that's the key. I think if there's any doubt, I would err on the side of caution and direct them to be seen by one of the clinics that are operating for emergencies.
What happens if employees are laid off longer than the 13-week temporary layoff period in an office where there are no benefits paid or continued through the layoff?
As I mentioned earlier, a temporary layoff can exceed 13 weeks, provided you're paying an employee an amount of money or benefits are provided. If you're not doing either of those, an employee can agree to extend the layoff beyond the 13 weeks. So employee agreement would suffice, and then you could continue it. If an employee doesn't agree, then you'd be in a situation where under the Employment Standards Act, their employment has terminated. So it raises, again, a number of questions. What a termination in that situation, in the context of COVID and the shutdown of dental practices, what all that means. It may amount to a frustration of the employment agreement, and there may be no obligation. So it depends on how courts and the labor board will view the the circumstances and the employee's decision not to accept a continued layoff.
Quick one here. Somebody asked how many people responded to the poll. Sean, I think it was 40,
Yeah, it was 40.
40. Somebody marked down here that they feel that CEWS is still very undefined. I would certainly agree with that. I like this question here. Can you require employees to do online training if they are on CEWS?
I think you run a bit of a risk if you, I think the training would be viewed as work, and to ask an employee to work without compensation really is inconsistent with the Employment Standards Act.
Sorry, David, if they're on CEWS, if you're covering their salary.
Oh, if they're, I beg your pardon, if they are on CEWS, then certainly having them perform work is appropriate, as would be training, and whether it's online or at the office. Obviously, they should be compensated for any time they spend with respect to work. So, you know, it ought to be during these notional work hours if the office isn't open.
Yeah, it's important to reiterate the distinction between the CERB, which is a subsidy or benefit to employees who are not working, versus the CWS, which is a subsidy to employers to keep employees on the payroll.
That's right.
Here's another landmine question. A lot of the dentists are using the same PPE for the whole day due to the limited quantities of PPE. And from a course that I've had before, it says that's okay to do so. Could that be possible for litigation by an employee? I mean, you know, recommendations are changing by the minute, I would say. You know, I know in the hospitals now, you know, ideally you'd want to swap it out for every patient, but they're wearing N95s for 8 to 9 hours and then tossing them. I think the gowns and stuff, they're still changing between patients. You know, with the N95s, a lot of people are putting a level 1 or level 2, level 3 mask over the N95. You know, is that something that an employee could get liable on? I think during this time, you know, you might get away with it. I'm hoping that the manufacturers are going to get caught up by the time we get back to work, right? We're at least a month out. I think there's going to be a lot more solutions for PPEs as time goes on.
Yeah, I mean, I would reiterate the point that was made earlier about monitoring and complying with industry standards, whether that's RCDSO, whether that's MOH. I think you need to be on top of whatever the guidelines are and ensure that you're not falling below them. And it's fluid. I mean, we keep repeating it, but you know, every day is like a month's worth of information and change. So the importance of monitoring and staying on top of things as much as possible is critical.
The challenge is, Harold, that we're not getting the information or the guidelines at this point. I think, you know, they're probably a good month out, would be my guess.
Fair enough.
So I don't know where we want to go here. We were started at 2:05. We were hoping to go till, you know, half an hour, 45 minutes. We're past an hour right now. There's still or close to 70 people on. Do you want to keep going, or is there? It's funny. One of the questions that patients often ask me, you know, towards the end of a consult, they'll look and say, you know, is there anything else, knowing what you know, that I should be asking? And I always think it's a great statement. You know, like, Harold, is there anything that you, from a, you know, business law person, is there stuff that maybe people should be cleaning up right now, or getting their leases in order, or is there stuff that you think people should be doing while we're waiting around looking for stuff to do?
Other than like cleaning up the house?
Yeah, maybe getting their wills or estates in order or something. I don't know.
Wills and estates is certainly a good one. I mean, in terms of the practice, I think just as a general comment, and this applies across the board, both in terms of your own homes and your businesses, there are always things that you intend to do that you never have time to do. Now we've got, many people have lots and lots and lots of time. So, I mean, certainly your lease, your employment contracts, these are all things that if you haven't had the time to deal with, by all means. If you are looking to start selling a practice, you can, I think, start that process, although it's obviously difficult now. But just in terms of the prep, is there stuff that you could be doing in terms of the structure of your professional corp, so that you will qualify for the capital gains exemption if you sell shares. So these are all things that, in terms of like structure and preparation, people could be thinking about. And as I said, it may be a situation where you had a wish list of things that you just haven't been able to get to, and now's the time to start knocking items off of that wish list.
David, anything you would like to add that you don't think was covered, or that you'd like to touch on, specifically employment law-wise? I know it's such a fluid situation. It's probably hardest for you to answer that.
It is a fluid situation. I echo what Harold had said. During this period, examining your employment agreements, employment policies, perhaps, is always a good idea. I think you need to be wise about how much of your precious resources you are spending on additional advice and guidance from professionals, but it may be a good time to do some of that.
Cameron, I would just add maybe,
Yep.
as I was thinking about the question, it's not so much what you can do during your time off. It's really about how to deal with information and misinformation. A basic principle in law is that the devil's in the details. So your lease, your insurance policy may not be exactly the same as anyone else's. So I would caution people from relying on articles that may be written by lawyers or accountants about general situations. We talked about the one about employment law. There are articles out there on getting out of leases or getting out of paying rent. There are articles out there about claiming business interruption coverage on your insurance policy. It's very difficult to write an article that applies across the board. So I think you need to be very mindful about the fact that your lease, your business interruption policy, everything is unique to you, and you need to get those looked at by a professional before you rely on comments from a friend or a colleague or a brother-in-law who may say, I did this and this was the result. While we're talking about insurance policies, you may not have to take no for, you may not want to take no for an answer. I think insurance companies, their first response will likely be no to claims. I think the vast majority of the time that will be the right answer, even though it's the wrong answer for the insured. But I would have, if there's enough at stake, I would have that looked at. And it may be that insurers are saying no to certain claims that in law they should be saying yes to. But they're not going to do it without a bit of an arm twist.
Yeah, it's funny. I asked my insurer if we had coverage, and he said no. And then I said, well, I want you to send me the part of the policy where it specifically says I'm not covered for this. Mm-hmm. And lo and behold,
still waiting.
He actually sent it, and I'm actually filling out the incredibly complex forms and detailed loss of billings, et cetera, et cetera. So that was about 2 weeks ago we started the process. But anytime somebody says no to me, I don't hear it the first 3 times. So I definitely dug into it, and it looks like we may have a claim. So
yeah.
Pam says hi. Hi, Pam. Can you host a meeting for dentists who are thinking of transitioning now? I wonder if there are a number of dentists that are thinking of selling, retiring now. Probably all of them right now, Pam, are thinking of selling and retiring right now. We actually, it's funny, we looked at maybe bringing Neil Pressner and Bernie Delansky on to this panel, and just we thought it might get a little bit too confusing, but maybe we'll reach out to them and see if we can't put something together for them. Oh yeah, here you go. Neil's saying yes, we'll set it up. So there's definitely some. The other question I'm getting here too, and again, it's amazing, I'm getting questions, chats, and text messages being sent to me right now. People are wondering if maybe as this gets a little bit closer to opening, would you guys be willing to be re-interviewed and be able to modify or update your suggestions?
Sure.
Would you make yourselves available again, let's say in a month from now? Or
absolutely.
I'm
Speaking
assuming
for myself.
Yes. Okay.
Yeah.
I'm assuming we're gonna get some lead time when we go to start back up, right?
I mean, this is a great forum to connect with a wide number of people and share hopefully relevant and useful information.
Perfect. Sean, a few people have asked if this is being taped.
It is being recorded. I'll send out a link afterwards.
Beautiful. Well, guys, we're well over an hour. I'm thinking we wind stuff down at this point, and we've definitely roped Harold into doing one of these presentations again. David stayed suspiciously quiet on that one, so
I'm happy to get on another one if you'd like me to.
Awesome. You were on the hot seat a bit more. And Sean, I don't the Zoom connection, is it our side on this that's happening where it's fuzzy, or every Zoom meeting I've been on lately has been the internet's been going down? Is there something that we can do to work on that?
I think it might have just been in David's case, he's a bit far away from his router or something. For me, it was pretty good.
Yeah,
Was it?
Mine was fine. It's probably a Wi-Fi connection issue.
Excellent. Okay, and a bunch of people saying that it was clear and that you guys did a great job. So we're getting good feedback from the group on both Harold and David. So thanks very much, guys, and everybody stay safe and healthy. It's no joke, this virus. Mansour Haas, the endodontist in Toronto, was on a webinar with my good friend Steve Bongard yesterday. He was the endodontist who spent 6 days on a ventilator in Toronto. A super fit and healthy guy. I think he picked it up from travel, or it seems like it was from travel. So don't take it lightly, and everybody please stay safe, and thank you very much for joining in. And Sean, you're sending out an invite for the chat for next week, where I think Dr. Alibi is
going to be talking about antibiotics and analgesics. Yeah.
Beautiful.
And thank you, Sean and Cameron, for giving us the opportunity. Much appreciated. And for my wife, she finally saw me in something other than a hoodie for the first time in a few weeks. So thank you from her as well.
Yeah.
Thanks for
Same for me. I appreciate the opportunity, and I promise I'm going to deal with my internet service provider as soon as we hang up.
Thanks, guys. Take care. Okay,
Thanks, everybody. Bye, everybody.
Thanks, everyone.
Take
Stay
care.
safe.
Bye-bye.